All right, good afternoon, everyone. I'll call the Senate Committee on Growth and Infrastructure to order. Will the secretary please call the roll?
Senator Brooks? Here. Senator Hammond? Here. Senator Pickard? Senator Spearman? Chair Harris?
Here. Please mark Senators Spearman and Pickard present as they arrive. I believe they are in the building. All right, let's just jump right into it, guys. Hopefully you're pretty familiar with how this committee works at this point in the session, so we'll just jump straight to testimony. We'll open up the hearing on AB 403, and I'll welcome Assemblywoman Brown May. Welcome.
Thank you, Chair, Vice Chair, members of the committee. I have to just say, as we begin this, how wonderful it is to be able to be here in person to offer testimony. And I understand from our committee secretary that this is the first committee you're going to hear in-person testimony today. So we're thrilled that it could be us.
Not quite. I think this is our second in person. Oh, that's right. We didn't have any guests. So you're the first to have an audience.
Wonderful.
Don't mess it up.
I'll do my best. Okay, I am very pleased to be here today to present Assembly Bill 403. For the record, my name is Assemblywoman Tracy Brown May, and I proudly represent Assembly District 42, which is in central Las Vegas in Clark County. My co-presenter today is Ms. Kendra Birchie with the Public Defender's Office, and she'll come up and present some bill specifics so that we can walk through the language. I am a mom, a dog walker, a reformed runner, and a current cyclist. And as such, I spend a significant amount of time on our city streets. As a pedestrian, I have recently become aware of laws that really affect criminal prosecution opportunities for folks that choose to cross the street safely, albeit not in a marked crosswalk, which was very interesting for me to learn about. Now, Miss Ida lives in my neighborhood. And Miss Ida likes to cross the street to say hello to her neighbors, and she always does it safely. But recently I found out not legally, which I think is an interesting provision. So there's a significant difference between crossing a marked street safely and legally. This bill as presented decriminalizes certain violations by pedestrians, most commonly referred to as jaywalking. While crossing a street outside of a marked crosswalk is and can be a safety hazard if there are cars present or other road hazards, and it should be a deterred behavior when safety is at risk. A criminal charge for violating this statute is unnecessary and can be excessive. Now, Nevada's current law criminalizes jaywalking as a misdemeanor, which is punishable by imprisonment in the county jail for not more than 6 months or by a fine of not more than $1,000, or by both a fine and imprisonment. So this bill before you would decriminalize jaywalking. It's important to note that this bill does not eliminate penalties or citations for jaywalking. It does instead direct the courts to consider this citation as a civil infraction, not a criminal infraction. Chair, with your permission, I'd like to introduce my co-presenter, Kendra Birchie, who is the Deputy Public Defender with the Washoe County Public Defender's Office, and she will walk us through the bill sections.
Thank you, Chair. Thank you, Assemblywoman. Kendra Birchie with the Washoe County Public Defender's Office for the record. As you can see, this is a short bill, but a very important bill, and one that is fiscally sound policy. The way that NRS 484B.287 currently reads is a little strange because it does provide for a criminal penalty for what in essence is just someone walking in an area where they shouldn't be, where they needed to use the crosswalk. As indicated, this section, what it really just does in subsection 2 is create that civil infraction, so it's not a misdemeanor, that is punishable with a civil penalty of not more than $100. So that means that the judge can still sentence them and punish them accordingly within that range. There could be other punishments that are allowable. There could be programs if the court has them. So those are all at the judge's discretion and their disposal. What's important to know is that misdemeanors have significant consequences. For example, individuals who are applying for medical school or nursing school, they currently have to say if they have a misdemeanor on their record. And so that's why it's really important just to provide for some equity to have this be a civil infraction rather than a misdemeanor. In researching our jaywalking laws in Nevada, I came across an individual named Mr. Farr who has a web scraping tool to look at who's currently in custody on jaywalking. For the hearing, for your information, as of this morning, there are currently 5 people in the City of Las Vegas jail with just jaywalking charges. So we don't have any information from the Washoe County Jail, and it's our understanding that no one in the other detention facilities. But today alone, those individuals cost taxpayers $190 per day in the Clark County Detention Facility. So for those 5 individuals, we are spending today nearly $1,000 just to house them for one day. And that's only if they're healthy. In the Washoe County Sheriff's Department, it costs $126 per day, up to $500 per day for each individual. It's important to note that 2 of those people who've been in custody at CCDC have been in custody since Thursday, April 22nd, on just jaywalking. So again, that is the only charge that they are in custody for is jaywalking. So Section 2 is important because it creates that civil infraction rather than a misdemeanor. Then for Section 2.5, this section allows for those who are currently have a warrant pending for them to have that warrant, as we call it, quashed, so that they no longer have that warrant hanging over their head, just to provide for some equity under the law, because if it becomes a civil infraction, there wouldn't be that warrant for their arrest. For your information, when this was heard in front of the Assembly Judiciary Committee in the Las Vegas Municipal Court, there were 4,515 individuals who had outstanding warrants for just jaywalking. If those individuals were arrested today, again, just warrants for Las Vegas Municipal Court, it would cost taxpayers $898,485 for just one day for each of those, for those individuals in total. So we urge your support because this is smart criminal justice policy-wise and fiscally responsible. And with that, we're open for questions. Thank you.
Thank you so much, Ms. Birchie. I have a question for you before you flee the table. What would happen to those 5,000 or so many folks who currently have warrants in place if this law were to pass? Would those warrants still be outstanding and they could be picked up at any moment? If so, how would they possibly be sentenced? Could you tell me a little bit about how this bill would affect those folks?
Thank you, Chair Harris. For the record, Kendra Birchie with the Washoe County Public Defender's Office. In Section 2.5, subsection 2, that's where it discusses how the outstanding bench warrants would be canceled or vacated. So it would automatically be done where each jurisdiction is required to do that for all of bench warrants that occurred prior to July 1st, 2021. So on the effective date of July 1st, 2021, if this becomes law, then the courts would be required to vacate those warrants so that those warrants would no longer exist. They would still have those tickets. So then when they come to court, the court would then, if this does become law, it's retroactive. And so there would be the appropriate penalty based on that basis. But the main part is that they wouldn't have that warrant, so they would not be arrested if they didn't have a court hearing before July 1st.
Thank you. Any other questions? Senator Hammond.
Thank you, Madam Chair. Ms. Birchie, thanks a lot. And I really do like the bill, and I understand, I think the genesis of it and kind of, well, we did not participate in the conversations back when this bill was, put into place and the act of jaywalking was criminalized. I mean, it must have been a robust discussion. I don't know why. It basically boils down to me at least, as a deterrent. We wanted to make sure that we were discouraging people from doing something that might actually jeopardize their life or the lives of others who, may have swerved to miss them or whatever. So I can't imagine exactly what happened, but something like that. So now what you want to do is you want to get rid of it, decriminalize it, only have a penalty. The only thing I worry about is, currently I've know people who collect fines for Clark County, for example, that, that accumulate, and they kind of stopped collecting a lot of fines. If it gets to the point where they're not collecting the fines, if they're not staying on top of that, what then is used as a deterrent? What is going to dissuade somebody from doing it other than the fact that they're going to lose every time when a car is coming down the path, right? I mean, that's, to me, the biggest deterrent. I mean, if you're smart enough and you've got common sense, you don't cross somewhere where it's not safe. And I think that was your point, Assemblywoman, is that they do it safely because they look around and it shouldn't be criminalized. But I guess I'm going to go back to the question that I have, and that is that $100 enough of a discouragement? Are we going to make sure that, or it's up to $100? I'm sorry, I shouldn't say $100, but up to $100. Is it enough of a discouragement? Do you feel like they're going to stay on top of that? I just want to get your feelings on that, because everything we say here has an impact later on.
Thank you, Chair Harris, through you to to Senator Hammond. Kendra Birchie for the record. I think that's a great question, and that is something that we are debating for a lot of the infractions, for traffic infractions. There are several bills that are passing through the legislative body right now to decriminalize those, because of the studies that have shown that there is no deterrent impact by having it as a misdemeanor for these traffic offenses. The deterrent of the fact that they're going to have to come to court and to have to pay a fine is more of a deterrent. And I would just note that during COVID, it's my understanding that some court systems have stopped issuing warrants for some misdemeanor charges for traffic charges, and they've seen an increase in revenue because people are paying more. This would allow for individuals to still use the other resources of having to do community service, which are also deterrent factors. And I would just note that from the studies, there's nothing saying that because somebody would be looking at jail time, that's more of a deterrent. Rather, they're more likely to come to court, I would say, because they're not looking at the idea of they're going to be arrested and taken into custody for up to 6 months, where they could lose their jobs, lose their housing, lose their children. So this provides them with an ability to accept responsibility and know that the punishment is going to be more reflective to the crime or what had occurred.
Yeah, thank you very much. I appreciate that, Madam Chair. And really, it was, for me, it's just getting somebody to say that out loud and kind of talking a little bit about the research they've done, and I appreciate that.
Are there any additional questions? Okay, seeing none, we'll open it up to testimony in support for AB 403. I don't believe there is anyone in the room here to testify in person, and so I'll kick it over to broadcast to see if there's anyone on the phone lines who'd like to testify in support of AB 403.
Thank you, Chair Harris. Callers, if you'd like to testify in support of AB 403, please press *9 now to enter the queue. Will the caller with the last 3 digits of 725 please state and spell your name for the record? You may begin.
Hello, and thank you, Chair Harris and committee members. This is Nick Shepak, Nickshpack, Policy and Program Associate with the ACLU of Nevada. We want to thank Assemblywoman Brown-May for bringing this piece of legislation. Much like Assembly Brown-May, we do not believe that the average citizen is aware that jaywalking is currently a misdemeanor. Deterrents don't work when people are unaware that they exist. We believe that decriminalizing jaywalking is a logical move. As a state, we are starting to move away from the criminalization of minor infractions, such as minor traffic violations. And this bill is one more step in that direction. Minor tickets, such as jaywalking tickets, have disproportionate impacts on people of lower economic status in those rural areas where pedestrian infrastructure may not be as robust. While it is likely that we all have jaywalked in our life, individuals who are late for a bus or must cross the street without a clear crosswalk on their way to work are more likely to jaywalk than a person who has access to reliable transportation. If they receive a criminal ticket, these people are also the least likely to be able to pay that ticket or have reliable transportation to the courthouse to get the ticket reduced. Right now, an inability or failure to pay a jaywalking ticket results in a bench warrant, which can turn into an arrest. As you have heard in the presentation, depending on the jurisdiction, the arrest could translate into multiple days in jail and cost the taxpayer more than the original ticket. A civil penalty provides the same level of deterrent as a criminal penalty while alleviating many of the issues that arise from the current criminal penalty structure. Additionally, the vacation of bench warrants will reduce unnecessary contact between police, which is good for both the police and the citizenry. We urge the committee to support this common sense change to the penalty structure for jaywalking laws. Thank you for your time.
Will the next caller with the last three digits of 080 please state and spell your name for the record? You may begin.
Hi, Jim Hoffman, Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ supports AB 403. We do not believe jaywalking is the kind of social problem that should expose people to criminal liability, and we believe that civil penalties are sufficient to deal with this problem in a manner that saves costs while also ensuring public safety. Therefore, we support the bill. Thank you.
If there are any additional callers who would like to testify in support of AB 403, please press star 9 now to enter the queue. Chair, at this time, there are no additional callers wishing to testify in support.
Okay, thank you. Let's go ahead and see if there's anyone who'd like to testify in opposition to AB 403.
Thank you, Chair. Callers, if you'd like to testify in opposition to AB 403, please press star 9 now to enter the queue. Chair, at this time, there are no callers wishing to testify in opposition.
Okay, how about the neutral position?
Callers, if you'd like to testify in a neutral position for AB 403, please press star 9 now to enter the queue. Caller, will you please state and spell your name for the record? You may begin.
Thank you, Chair, members of the committee. My name's Chuck Callaway, Callaway, representing the Las Vegas Metropolitan Police Department. I signed in neutral on the bill. We are neutral on whether or not the penalty for jaywalking is a civil fine or a criminal fine. We don't really care as far as the penalty goes. If it's the appetite of this body to make it a civil penalty rather than a criminal penalty, we're fine with that. I do want to maybe dispel a few myths that have been floating around and just state some basic facts that I think pertain to this bill, however. Number one, we've had 38 fatalities on our roadway as of this morning in our jurisdiction in Clark County. 13 of those fatalities involved pedestrians, many of which were in the roadway or not abiding by the crosswalks at the time of the accident. Not all of those, that was the case, but in some of those it was. 40%, or excuse me, roughly 47% of our fatalities involve pedestrians. And law enforcement needs to have the ability to enforce these laws. We have people that routinely walk out into the middle of traffic on busy streets. If you go to DI and Maryland Parkway and look at the bus stop, for example, when the bus stops and everyone jumps off and they run across 6 lanes of busy traffic to try to catch the bus that's going the opposite direction, it is a recipe for disaster, and it's not uncommon for us to have pedestrian accidents there. And another myth that's floating around out there is officers are not driving through neighborhoods arresting neighbors who cross the street to chat. I would encourage you to look at those 5 people that are in the city jail. I don't know who those folks are. As was stated, I checked with the Clark County Detention Center this morning, and there were 0 people in the Clark County Detention Center for jaywalking. But check into those cases and see why they were arrested. Typically, if someone is arrested, it's because the behavior will continue. They're in the roadway, and just writing a ticket is not going to make them move. They're back out in the roadway again for whatever reason. Sometimes they're soliciting, sometimes maybe there's mental health issues involved, but there's usually underlying reasons as to why someone would be arrested. We actually have a policy on Metro that we don't make those arrests unless approved by a supervisor and it's needed, which reflects that 0 number in the Clark County Detention Center. Also, I constantly have heard this session, the cost, 190 days to incarcerate someone. I would like to mention that the jail is under a budget. We have a set number of beds that are either full or they're not full. So whether someone gets arrested or doesn't get arrested, the only cost savings there would be their food and their clothing for the day, which would be $20-25, not $190 a day. That money is still being paid in the budget to keep that bed open. The deterrent here in this big thing, it was discussed, is deterrent, is police officers. Police officers, studies have shown, are the deterrent. You're right. The person that commits the offense does not know what the penalty is usually, but they do know that if police officers are enforcing it, that does sometimes curb behavior and prevent someone from getting hit in the roadway.
Mr. Callaway.
On the assembly side, the
Mr.
chairman,
Callaway,
said that my testimony was actually opposition. So I just end chair by saying that we are neutral on the penalty. If you feel my testimony is opposition rather than neutral, feel free to classify it as you desire. Thank you, Chair.
Thank you, Mr. Callaway. I will allow you to characterize your testimony as you see fit, and we'll leave it in the neutral position. BPS, will you let us know if there's anyone else on the line who'd like to testify in the neutral position?
Chair, at this time, there are no additional callers wishing to give neutral testimony.
Okay, we'll go ahead and close out the testimony then on AB 403, and I'll invite you back, Assemblywoman, if you'd like to make any closing comments.
Thank you very much. I appreciate the opportunity to close out. As you heard from Mr. Callaway, we've had robust conversations with regard to policing on this issue. And he had stated on record that the police often have alternative means or reasons to arrest. And so for that reason alone, we believe that decriminalizing jaywalking as the reason to arrest somebody would be a very appropriate measure. And having the fines become in alignment with what the penalty is. Now, at no time would we ever encourage anyone to cross the street unsafely. We simply feel as though this is not a criminal act that should be prosecuted as such. I would also like to draw your attention to, I believe, a letter of support from the Attorney General's office, which should be uploaded to Nellis. Unfortunately, the Attorney General was not able to join us here in person today, but he did testify on the Assembly side and is in support of this bill as well. We're happy to take whatever questions you'd like if there's follow-up.
All right, thank you. I'll encourage members to follow up offline if they have any other additional questions. We'll close the hearing on AB 403 and open the hearing on AB 118. Good afternoon, Assemblywoman. I've been informed that one of your presenters is available on Zoom, but not all 3. It should be 2, okay? It's my understanding we have Dr. Cools, if I'm saying that correctly, but we do not have Dr. Chestovich or
Ms. Gritter.
Ms. Gritter.
That's fine.
Okay, well then we'll open up the hearing, AB 118, and welcome you. Go ahead and start when you're ready.
Yes, good afternoon.
I'm actually going to...
Sorry, I'm out of turn.
Oh, you are here. It's okay. I'm going to go ahead and start, and then I will turn it over to you, Doctor, if that is okay. Okay. Thank you. So exciting to be here in person. This is my first testimony in person. So thank you, Chair Harris, Vice Chair Brooks, and members of the Senate Committee on Growth and Infrastructure. For the record, I am Shannon Bilbray Axelrod, representing Assembly District 34 in Clark County. I am here to present Assembly Bill 118 for your consideration. A little background on this bill. Senator Joyce Woodhouse brought this bill in the 79th session. It was SB 156. It was passed out of the Senate and came to the Assembly Committee when it was called Transportation Committee. And although it did make it out of the committee, it never made it to the floor for a vote. That was the bill that I brought initially. That is not the bill that I am presenting today. I found that there was not an appetite for some of the changes that I included in my original bill, but I did not want to throw the proverbial baby out with the bathwater. So I salvaged a few things out of the original bill that I thought would make a real difference for the safety of kids in Nevada. The bill I bring to you today, AB 118, in its second reprint, does two things. It adds into statute that babies shall remain rear-facing in a child safety seat until 2 years of age. This is the recommended age from the National Highway Traffic Safety Administration, known as a NHTSA. Additionally, Assembly Bill 118 changes the weight requirement to safely transition out of a booster that is currently 60 pounds to a height requirement of 57 inches. Once again, that is the recommended measurement of the NHTSA. My original bill included not allowing children under the age of 13 to sit in the front seat. This bill no longer has that requirement, but I did want to get on the record that that is the recommended age. While this bill is not the bill I envision, I do believe that it will save lives if passed, and I thank you for your consideration. I will now turn it over to Dr. Deborah Cools, who is Chief of Surgery for UMC Trauma, Professor of Surgery for UNLV, and President of the Nevada Medical Society. And before I do that, really quickly, if you'll indulge me, I think everyone should have this on their desk. And just by passing these two provisions, that would get us out of that red. So although it doesn't do, like I said, everything, it does do a lot for the safety of our children. And with that, Doctor, please.
Yes, good afternoon. I'm going to try to share my screen. We have a brief PowerPoint presentation. Okay, and I assume everyone can hear me. Okay, so I'm a trauma surgeon at University Medical Center, which is Nevada's only level 1 trauma center and Nevada's only pediatric trauma center. I'm also faculty at the UNLV School of Medicine.
And doctor, if you could just identify yourself for the record, that'd be great.
Yes, Deborah Kuhls, Kuhls. Is that sufficient?
It is, thank you.
Yes, and for some reason my slide is not, it's not advancing. Okay, good. I also wanted to just disclose that our office does get funding from the Nevada Department of Public Safety, the Office of Traffic Safety, and some of the data that I'm going to present here is Nevada data, which is funded by this research. So we've already heard about best practices, and these are really corroborated by the American Academy of Pediatrics, and they advocate the same best practices, essentially. Infants and toddlers should remain in rear-facing child restraint systems in the rear seat from birth through age 2 or longer. When children get older, it's just difficult to keep them restrained in this position. When we look at booster seats, the current recommendation is that booster seats should be used until the child can properly be restrained in a regular seatbelt. And ages 8 and 57 inches in height are the standard of care. And if they are used properly, it really reduces the risk of serious injuries. Additionally, there's a recommendation that children less than or equal to 13 years should ride in the back seat of a motor vehicle. I think you've already seen this map, and the red state is for states that have neither the 2-year restriction on rear facing or the booster seat provision. And currently Nevada is red. States that are yellow have one of the two pieces of legislation. States that are green have both provisions. So I'm going to take you through some of our Nevada data, and this is years 2013 through 2017. And we look by race and ethnicity on appropriateness of restraint. And the green bar is children that were thought to be appropriately restrained. Yellow is inappropriately restrained. And again, this is by race and ethnicity, which is at the bottom of the graph. The red bar indicates children that are not restrained at all. And what we see is when we look at the green bars, the highest number is in our Asian population, followed by our white population. And if we look at Hispanic children, for instance, we see that they are less likely to be restrained, as well as Black children. And in addition, we see that Black children are more frequently inappropriately restrained. So there's clearly opportunity for improvement. I want to tie this into what happens to children when they get injured. They would come to our trauma center, and we've done an analysis on the red bar, those that are not restrained, the yellow bar, those that are improperly restrained, and the green bar, those that are appropriately restrained. And we can see, if we first look at hospital days, I don't know if you can see my cursor or not, but hospital days, you can see dramatic increase in hospital days, and it's very statistically significant. If we move over to ICU days, again, we see this stepwise progression of length of stay in the intensive care unit. And again, very statistically significant. If we go on to look at ventilators, so these would be children who are obviously in the ICU and in addition are on a ventilator, it is also statistically significant. So we can see that restraint status, as we call it, makes a huge difference in terms of injury. So if we also look at just the data on properly restrained and so forth, it's the graph over to the right. We see at the top that age-appropriate restraint use is reasonably high in the early ages of life and dramatically decreases during ages 6 through 8. We're not sure all of the reasons. It may be a lack of education, and clearly at present our law does not dictate that they be restrained properly. And if we look at no restraint use, while it is alarming that there are any children that are not restrained, we see that it just gradually increases as children reach puberty and teenage years. So it's really important that we know that improper restraint again leads to greater injury, and many of the children who die actually die at the scene and don't even come to our trauma center. So conclusion is that booster seats really save lives and reduce injuries. The gaps that need to be addressed are those that have already been mentioned, that there's a gap in ages 1 to 2, not required to ride in rear face child restraint. And those ages 6 to 8 are very vulnerable under our current laws. And all the recommendations are that they be restrained up to proper height. And again, there's no requirement in the Nevada law that children ride in the back seat until reaching 13 years of age. I'd like to thank you for the opportunity to present this data. And we followed this legislation and prior legislation very carefully. For those of us who are in the front lines and take care of these children, it really makes a difference in terms of not only their pain and suffering, but their outcome in terms of the rest of their lives. And we also see very often their parents who, when they realize that either they were out of their booster seat or out of the restraint system, we really have to work very closely with them because very often they're extremely guilty. It's really important that our legislation helps to reinforce best practice behavior. Be happy to answer any questions that you may have.
Thank you so much, Dr. Cools. We appreciate you being here. And for the secretary, I'll just note Senator Spearman is present, but on the Zoom. Are there any questions from committee members? Senator Pickard.
Thank you, Madam Chair. I wouldn't want to disappoint. I have a couple of questions with respect to the graph, the infograph that you gave us, and then specifically to the bill. As I understand the map section, these are laws that we're comparing just two of many laws that the state may have adopted, the rearward facing until 2 law and the booster seat law. Is that correct?
Shannon Bilbray Axelrod, for the record, that is correct.
Okay, and it's my understanding that we do have a restraint law that all children under a certain size have to be in some kind of restraint as is appropriate for their size, right?
Shannon Bilbray Axelrod, for the record, yes, currently it is 6 and 60 pounds.
Okay, and then looking at the bottom graph, the bar graph, these aren't comparing the number of laws as in the map, but this is whether the child was restrained or not restrained at all, restrained but inappropriately, or restrained appropriately. Do I have those right?
Shannon Bilbray Axelrod, for the record, that is correct.
Okay, so I wanted to make sure I didn't misunderstand that. So in Nevada, if we're talking about somebody that's following the law, I mean, we can exclude those, I think, for purposes of my question entirely, because if they're not following the law, then they're not following the law as it exists today. So in what we're dealing with in this bill is we've got a booster seat requirement based on size and age, and a infant seat or a car seat, a rear-facing car seat defined solely in age. The reason I am making this distinction is I've had a couple of grandkids and have a third that I expect. He's 7 months old and the size of a 1-year-old. I expect he will exceed the ordinary size of a 2-year-old by the time he reaches the year of 1 at the rate he's going. But we've had kids that are well above average in terms of height and size for their age. And my experience has been they reach 2 years of age and they're now kicking the back of the seat. Their knees are in their chins. They're just too big for that scenario. But this is tied strictly to age. If one of my grandkids were to be in a forward-facing seat because they couldn't fit in a rear-facing seat, are they now going to, is my child now going to be punished for not having their child in the right size of seat based on their age alone?
Thank you for the question, Senator Pickard. Shannon Bilbray Axelrod, for the record, and I will have Dr. Kuhn speak as well, but I would just like to say I've been working on this bill for a while, and really, honestly, the recommendation would be above 2 years old, still rear-facing, but I think Dr. Kuhn's kind of touched on it briefly. 2-year-olds are notoriously, I don't want to use the word stubborn, but have a lot of opinions.
I will.
So I think the age was more not really based on the size, but due to the temperament of a child, trying to continue them in that reverse facing position. That seems to be the appropriate time that a parent is no longer able to physically put a child in the back, not because of their age, but because of the temperament. And Dr. Cools, if you would like to elaborate on that.
Sure. I think the recommendation is, occasionally, if you take the opposite example, you can have some children that are small or have a milder temperament, even beyond 2 years of age. And so I think the recommendation is 2 years of age or as long as possible. So I hope that addresses that. And I just wanted to clarify the inches for booster seats. So anatomically, that would place a child at the appropriate level, particularly so the lower part of the seatbelt goes across their hips and not across their abdomen, because if it goes across their abdomen, then we see intra-abdominal injuries such as bowel perforations, solid organ injuries, and pelvis fractures.
And that was Dr. Cools, for the record.
Right.
Yes, I'm sorry. Yes.
All right, I guess we're back to square one, because I'm thinking that the appropriate position and situation for the child is going to be based on their size, not their temperament. I mean, kids at any age don't like to be, looking backwards when their parents and all the exciting stuff, the food and whatever else, might be up front. So they're going to put up a fight at any age if they're not, particularly the youngest children. But this bill doesn't approach the temperament piece, and we're far afield from my question. My question was, if we're looking at size and physical characteristics in the second instance, why aren't we using those same parameters in the first instance? In other words, we're using strictly an age restriction in the beginning, and the kid may not fit in that, whether they're too small to be, at age 3. One of my granddaughters is so small, I think she could have been 5 and still been rear-facing and fit in the chair. But this doesn't look at the physical characteristics of the child that would make it appropriate. This is looking strictly at age, and then we talk about for the booster seat. And I'm wondering why that is.
Shannon Bilberry Axelrod, for the record. Well, I think, number one, we went off the national safety recommendations, but I would also say as a parent, if my husband is 6'4", so I did not have that issue with my daughter, but I did keep her rear-facing until she was 2. However, if I did have a little bitty child, like I was actually, I think that I would, as a parent, even though I could turn the child around at 2, I think I would still keep them. And I think that the language is saying up to age 2, but obviously if your child is little bitty, then I would probably, if it was my child, keep them turned around. Dr. Cools, did you want to expand on that?
So in my review of all of the best practices for the 1 to 2 years of age, all the recommendations are to 2 years of age. I can understand some of the size discrepancies. The AAP recommends 2 years of age or longer if possible, is how they address that. And I'd be happy to answer any other questions about the older children if there are any. And this is Deborah Cools for the record.
Well done, thank you. And Senator Pickard, I believe Dr. Cools did point to the fact that the 57 inches has to do with when the seatbelt is around a child's hips. And so at least that answers why the height requirement there and no height requirement for the booster seat, although
Sure.
I understand it doesn't cover every scenario.
Sure, no, and I get that, and I take no exception to the 57-inch standard. That does make sense, because that's about placement of the seatbelt. But where we're not talking about the criteria of the child or the seat, we're just looking at rear facing, and we're basing that on what is really an arbitrary designation, which is 2 years, as opposed to the critical issues, which is whether or not the child fits in a rear facing seat. I think that we may be a little off the mark there, but I certainly appreciate the intent of the bill. I want to keep kids safe, and it's really about a compliance issue. If the kid isn't going to fit, people aren't going to comply, and now we make it a crime. I struggle with that. Thank you.
Are there any additional questions? Okay, if not, I have one. And Assemblywoman, you can take a shot at it, but I think it might be more appropriate for Dr. Cools. My kid loves to sit in the middle seat. Is there any guidance on whether children are safer on the edges, or if it's perfectly safe to sit in the middle? Has there been any research done on that?
I'm going to take a stab at it just as a mother myself, and I always had my daughter in the middle, especially when she was rear-facing. And what I was told, and Dr. Cools, you can chime in, was that if there was a side impact, the safest place would be for her to be in the middle. But I am not a trauma surgeon, as Dr. Cools is, so please.
So there is data on the two sides versus the middle. I think if someone is unrestrained, they have a clear shot to the windshield. But with restraint, my understanding is it's slightly safer if they're properly restrained. I didn't bring that data with me today. I think the most important thing is that occupants and drivers are restrained, and that is the area of the most robust data in all of traffic safety. I also just wanted to mention, I asked one of my research collaborators to really look at death data, and it's really important. We didn't present it here today, but there is increased death as well with improper and a lack of restraints, and I don't want us to lose track of that. When we look at trauma center data, we get the people who arrive alive and who may subsequently die. Those who die at the scene, they don't come to a hospital, and so they're captured in a different source of data. And this is Deborah Cools for the record.
Thank you so much, Dr. Cools. Any additional questions, Senator Spearman? No? Okay, seeing none, we will go ahead and then turn to testimony. I don't think we have anyone here in person to testify, and so I'll turn it over to our capable team at BPS to pull the line for those who'd like to testify in support of AB 118.
Thank you, Chair Harris. Callers, if you'd like to testify in support of AB 118, please press *9 now to enter the queue. Will the caller with the last 3 digits of 918 please state and spell your name for the record? You may begin.
Thank you. My name is Leanne McAllister, LEANN-MC, capital ALLISTER. I am the Executive Director of the Nevada chapter of the American Academy of Pediatrics. Today I offer testimony in support of Bill AB 118 on behalf of the Nevada AAP. AB 118 is an important step in bringing Nevada in line with American Academy of Pediatrics recommendations. The AAP offers 5 evidence-based best practices to optimize safety in passenger vehicles for all children, from birth through adolescence. These best practices are detailed in the written exhibit I submitted earlier today and are currently posted in Nellis for this bill. The Nevada chapter of the American Academy of Pediatrics currently has more than 260 members, most of whom are board-certified pediatricians, both primary and specialty care. Members also include pediatric nurse practitioners, physician assistants, pediatric residents, and medical students, all of whom live and work in Nevada and have dedicated their professional lives to the health of all children. Our chapter members are available to Nevada legislators to answer any questions you have about car safety or any health concern that impacts children, adolescents, and young adults in Nevada. Thank you.
Will the next caller with the last three digits of 622 please state and spell your name for the record? You may begin.
Hi, my name is Heather Watson, W-A-T-S-O-N. I am a child passenger safety technician instructor in Las Vegas. I train local technicians how to work with parents in installing car seats. I would like to address a little bit about the rear facing to age 2 because I know that was a question that was brought up earlier. Rear facing to age 2 is vitally important because the reason we do that is because of the neck bone strength. Until about age 3 or 4, neck bones aren't completely ossified or hardened. And in fact, it's not until much later, but that's about age 3 or 4 is about when that happens. And so that's why we want kids rear facing until a minimum of age 2, but there's really no set time as to when that happens because each child is individual on that timing. Age 2 is, again, kind of that minimum milestone. So that's why we want that to happen. The kids will figure out their legs. They'll sit crisscross applesauce or hang them over the sides. My own daughter rear-faced until age 3, to give you an idea. Size really isn't a factor. It's important that we bring Nevada up to our other states in minimums as far as not only rear facing, but also booster seat usage. As Dr. Cool said, booster seats, that age range is really important to get our kids back into our seats. I think our parents are thinking that after age 5 or so, the kids don't need to be in car seats anymore. So putting them back into booster seats and keeping them protected is really important. Thank you for your time.
Chair, at this time, there are no additional callers wishing to testify in support.
Okay, we'll open it up to those who'd like to testify in opposition.
Callers, if you would like to testify in opposition to AB 118, please press star 9 now to enter the queue. Chair Harris, at this time, there are no callers wishing to give testimony in opposition.
All right, let's see if there's anyone who'd like to testify in the neutral position.
Thank you, Chair. Callers, if you'd like to testify in a neutral position for AB 118, please press star 9 now to enter the queue. Chair, there are no callers wishing to make a neutral testimony.
Okay, we'll close out the testimony portion of the hearing, and I'll turn it back to you, Assemblywoman, if you'd like to make any closing comments.
Thank you very much, Chair Harris, for hearing this bill. I did neglect to point out one other thing that I entered into this bill, and is giving the Department of Public Safety the ability to receive grants or donations for donations of car seats and boosters, which I thought was important for folks who are in financial need. And I'll just leave it with this. Becoming a parent is one of the greatest things you'll ever do, but one of the scariest things you'll ever do. And, you just kind of want to know what's best practices for keeping your kids safe. And as I say often, and quote, I believe it's Maya Angelou, when we know better, we do better. So thank you very much.
Thank you so much. And just quickly before we close out the hearing, I just want to note that, I saw those numbers and the disparities in who are using these seats, and I would absolutely love it if there was some way to maybe encourage some educational outreach as part of this as well, and so that certain communities are not disproportionately affected by the fines that are associated.
100%. Thank you. I will continue working on that.
All right.
Thank you.
Thank you so much. We'll go ahead and close out the hearing on AB
Madam Chair?
118. Yes, Senator Spearman, go ahead.
Yeah, I was just going to say, the idea that you just suggested is a great idea, and we've been trying to get that done, I guess, since about 2015. So if they could do some outreach, that would be great.
The Assemblywoman is saluting you and nodding her head in the affirmative, and so we will continue to work on that. Thank you so much. All right, I'll go ahead and close out the hearing on AB 118 and open the hearing on AB 320. Welcome Assemblyman Levitt to the committee. You can go ahead and begin when you're ready.
Thank you, Chair Harris. For the record, I'm Assemblyman Glenn Levitt, representing Assembly District 23 in Southern Clark County, and I am here to present Assembly Bill 320 for your consideration. Nevada is a beautiful state, and although it's known for its vast desert, it is also home to mountains, lakes, rivers, and forest trails. Over 80% of Nevada's land is federally owned, and it's home to over 20 state parks, not to mention 2 recreational areas, 13 designated wildlife areas, and 7 national forests. Nevada is a tourist destination for those who enjoy exploring outdoors using off-highway vehicles, or OHVs, and many residents have taken advantage of OHVs to safely spend quality time with friends, family, especially during this COVID-19 pandemic, while enjoying all that nature has to offer. One specific type of OHV is a large all-terrain vehicle, or ATV, and I want to be very clear that AB 320 is only referencing large ATVs and not the other types of off-highway vehicles. As amended, AB 320 provides a definition for large ATVs as any ATV that has a non-straddle seat, including seating capacity for at least 2 people. Let me note that we are working to amend that language. We found out that large ATVs that fit this definition, you can also seat 1. So we wanted to make that clear that we don't want to omit these large ATVs if they only seat 1 person, but the non-straddle will still apply. These are not small vehicles. Some may approximate smaller economy-sized passenger cars in terms of dimensions. As such, moving large ATVs from one trail location to another can require a much larger vehicle with either sufficient truck bed or towing capacity to move a large ATV if it's not able to be driven across specific roadway areas. This bill seeks to allow large ATVs to meet certain requirements to be operated in certain city streets and highways in order to remove barriers to the owner's ability to access Nevada's many trails and recreational areas. Let me note that this bill came out of a constituent request saying that they could not drive their OHV from their garage to the trail, which is less than a mile from their house. And so that's how this kind of this came about. Quickly, the bill summary. Assembly Bill 320 as amended makes 2 changes to the existing statute in Nevada Revised Statutes 490.105 by allowing the operation of large ATVs on a main county road or city street within the city whose population is less than 2,500 or portion of the highway that has been designated as a main county road in certain circumstances. Specifically, large ATVs must conform to the requirements set forth in NRS 490.120 and be registered with the Department of Motor Vehicles as a vehicle intended to be operated on street highways. However, the governing body of a city or county having jurisdiction over the street or highway may enact an ordinance or resolution prohibiting the operation of large ATVs on any portion of such a street. By limiting the applicability of AB 320 to cities with populations under 25,000 and ensuring that the governing body of the city or county is the final authority by which roadways permit large ATVs to operate. This measure balances the need for outdoor recreation enthusiasts with the need for public safety. That's all I have in my opening remarks, and I'm happy to answer any questions that you may have.
Thank you so much, Assemblyman. I have a question. Do you know what the current requirements are regarding helmets for these? Are we going to have people who, I mean, are they enclosed, so maybe you don't need a helmet? Because I know when we drive our cars, we don't have helmets on, but I don't know the difference between a large ATV and a smaller one, but I'm envisioning maybe something that's open air that we might want people to have their helmets on, especially if they're on the highways. Are these vehicles people currently wear helmets on? Are they opened? What would that look like?
Thank you, Madam Chair. Glenn Levitt for the record. I asked that same question and was told that in certain circumstances they're not required because they have seat belts and because they're a fully enclosed cage. So if they were to roll or to do anything that perhaps could happen to a car, they're actually a little safer because they are often required to have a 3-point harness as a safety belt, and they're fully enclosed in a cage. Also note that in order to drive on a public street, they have to have all the things that a vehicle would have to have: signal lights, tail lights, review mirrors, all those things that are required to operate on a public street.
Okay, I think that's the only question I have. Is there Senator Hammond?
Thank you, Madam Chair. Assemblyman, welcome to the Senate. And it's a great bill. I understand the genesis of the bill. One of the questions that I had pop up that somebody had texted me about, you answered quite quickly, and that is the ability of counties and municipalities to still be able to pass ordinances. The one question I have, since you're going to be allowing people to be driving on roads and streets in areas with populations under 25,000, I get it, it's a rural area. It still, though, would this bill require somebody, as you mentioned a second ago, the vehicle itself, in order to be able to go on these roads and streets, has to have the same legal standards as a regular vehicle would? What about the driver of the vehicle? Would that person need to have a valid license in order to be able to drive on the streets and roads during that time? And then, when they get off the roads, whatever the requirements are for, whatever driver at that point.
Thank you, Senator Hammond. For the record, Glenn Levitt. I got asked that same question. Yes, they would have to have a driver's license. They would have to have everything that requires you to drive on a city street. So they would have to be licensed. These vehicles are insured, and so everything that's required to operate on a street they would have to have. I heard something about someone having a bill that would allow their 14-year-old child to drive one of these to school, but that's not in this bill.
Thank you very much. That's all I had. Thank you, Madam Chair.
Senator Pickard.
Thank you, Madam Chair. And that just raised an interesting question in my mind, Senator Hammond's question. When we're talking about the qualifications of the driver, I'm assuming then if they have a DUI or some other purpose for a suspended license, that they would be suspended on the roadway. But what about off the roadway? Would that sort of impediment prevent them from being able to drive these off road, or how is that addressed? Do you know?
I am not. Sorry, excuse me, Madam Chair. Assemblyman Levitt, for the record, I am not sure about that. I don't know what the qualifications are for driving the vehicle off road. The only research we did was what would be required for these vehicles to operate on a city street.
All right, so we're not changing any of that. Whatever they are, and we're not permitting anything beyond the existing impediments to driving on or off the road. We're just making sure that this applies everywhere. Is that right?
Assemblyman Glenn Levitt, for the record. Yeah, correct. We're in this. The bill has no language changing anything for off-road use.
All right. Thank you, Madam Chair.
And Assemblyman Levitt, Senator Hammond's question also brought another question to mind for myself. You mentioned that these vehicles are insured. this may be a question that you might have to come back with, but it seems to me that the insurance policy expects these vehicles to be used off-road and may only cover accidents that happen in their use off-road. And so if you have the answer now, I'd love to hear it, but if you don't, I'd love for you to come back. Do you know if insurance policies would hold drivers liable for accidents on the road if they are at fault?
Thank you for the question, Madam Chair. Assemblyman Glenn Levitt, for the record, I don't know. And I can look into it and I can get back to the committee and just let you know. I mean, my first assumption is that the insurance level is pretty high, even when you're operating off-road, because of the possibility of something negative happening while you're operating the vehicle. But I'll definitely look into that and see what the requirements are. They do have to, they currently have to register those vehicles with DMV, so I'm sure the DMV will know what the requirements is for the insurance.
All right, and thank you for that. And I want to let you know my concern, by the way, is not necessarily so much the cost of an accident, but occasionally, if you are not using something as it's intended to, let's say like with the warranty's not going to cover it, right? You were using it improperly. And so I just want to make sure we don't have a similar situation when it comes to insurance, right? We've agreed to insure you for the activities that we expect you to participate in an off-road vehicle that may not cover on-road driving.
And thank you, Madam Chair, and Glenn Levitt, for the record. How I would envision it is that they have to have equal or better insurance than like the operation of a golf cart, which is legal on some roadways in the state.
All right, fair enough. Any additional questions before we open it up for testimony? All right, seeing none, we have no people here to testify in person, so we'll open it up to the phone lines. BPS, if you'd like to see if there's anybody who'd like to testify in support.
Thank you, Chair Harris. The public line is open and working. However, there are no callers on the line at this moment.
All right. So let me make sure I understand that. That means there's no one at all on the lines?
Yes, that is correct.
Okay, that'll make this quick then. We'll go to testimony in opposition.
Chair Harris, there are no callers on the public line. However, it is open and working.
And anyone to testify in the neutral position?
Thank you, Chair. At this time, there are no callers on the public line.
All right, thank you for that. We'll go ahead and close the testimony. I'll kick it back over to you, Assemblyman, if you'd like to make any closing comments.
Well, I wish this was a more glamorous bill, but Assembly Bill 320 provides the opportunity for owners and operators of large ATVs to continue to explore Nevada without requiring another vehicle to move their vehicle. The measure preserves the jurisdictional authority of the cities and counties to permit operation of large ATVs on their roadways as they determine appropriate, and it requires registration of all such large ATVs with the DMV. Chair Harris and committee members, this concludes my remarks on AB 320, and I urge you to support this measure. Thank you for your time.
All right, good to see you, Assemblyman. We will go ahead and close out the hearing on AB 320, and we'll turn to the last item on our agenda, which is public comment. BPS, is there anyone on the line?
Thank you, Chair Harris. At this time, the public line is open and working, and there are no callers.
All right, with that, we will close out the hearing for today. We will have our next meeting Wednesday, April 28th at 3:30 p.m. See you all then. We are adjourned.